Hello, everybody. Nice to meet you. Like Michelle said, I'm Chris Young. I'm the attorney, and Erik is the smart one. He went to a lot more schooling. No, we actually do two sides, as you'll see, two sides of the same type of work. We're both helping seniors in the work that we do, but we approach it from two different directions. So since my introductions first, I'll just do this and then hand it back to Dr. Lande. I am with the Alvarez firm. It's a law firm of 11 attorneys. We have offices in Camarillo, Calabasas, and San Juan Capistrano. But I live here, and so I enjoy being in the Camarillo office as much as possible. And that's the phone number and website there. And these are the areas that I focus on. Our firm also has real estate and business law focus, and we do litigation related to all of these things. But these are the areas that I focus on. As you see, elder law, and I've broken out conservatorship there, even though it's really a component of elder law because it's such an important thing for a lot of people. And the last thing there at the bottom is the state bar likes to differentiate attorneys and make it clear which ones have really kind of done the extra education and whatnot to say that they can specialize. You can't use the word specialize as an attorney in California unless you have a designation from the bar. So that little symbol there with the bear on it says that I focus or I specialize in this area of law. So that's enough about me.
Thank you. And I'm Dr. Erik Lande. Chris and I had actually known each other for a number of years. We've given several talks together, sat on boards together. So we've done a lot of these types of things, and as you said, we'd be happy to take any questions. One thing I will point out, obviously since there's a legal component, we're going to talk about some legal paperwork. Just to check, does everyone know what a neuropsychologist is? So I'll mention that really quickly, and then we'll get to the important stuff. A neuropsychologist is a type of psychologist who has some extra specialty in the brain and how it relates to our behavior. So I can still do therapy of people and help people determine if they're having problems with depression or things like that. But really what I primarily do is evaluations to look at people's thinking abilities. So sometimes I'm asked to see someone to determine, like our topic is today, does this person have dementia? Or really more importantly, how is their dementia affecting them? What type of help or support do they need? Because it's not just enough to know if you have dementia or not, but really what matters is what it's doing and how we can help our loved ones. We also see other things ranging from young people maybe having learning disabilities or ADHD to people who might have a stroke or a brain injury or really any type of difficulty. Even with COVID, we've had people refer to us recently because of some of these long COVID issues. Oh, yes?
Do you treat PTSD?
So the question was, do we treat PTSD? And in general, psychologists do treat PTSD. In our practice, we do treat PTSD. One thing I'll just mention as a really quick aside, for a lot of people, when you think of psychological difficulties or psychiatric concerns, you think about medication. As Americans, that's where we tend to go. One thing I will say is all the research shows for psychiatric conditions, the best approach is usually a combination of therapeutic work and medication. For example, for PTSD, there's actually no medication for it, but when people get medication, it's to control the symptoms. So medications to help someone calm down and stop panic attacks. Doesn't get rid of the disorder though, that's where psychologists come in. Because our treatment can help people kind of reduce their levels of distress so that hopefully they're not developing panic attacks. But just to kind of answer your question. And if people have other questions about those things, happy to talk about them at the end. So like I said, my contact information is on there. And also I put up a little QR code in case anyone's really high tech and just wants to get the information using that. So what we're going to be talking about today is in general, what is conservatorship? Because one thing people often realize when they have a loved one who has dementia or really any brain impairment, be it from a brain injury or any condition, is that sometimes people may not make good decisions or may have trouble caring for themselves. And in those cases, the courts have given us something we can do to try and support the person. You know, obviously we can do things like help people organize their bills, maybe even help them pay their bills, but there are court procedures in case someone needs to step in, be it an individual, family member helping out, or for someone who has no one, there's organizations like the Public Guardian's Office. So that most extreme version of help is a conservatorship. That's where a court has determined that someone is unable to manage themselves and they need further support. Chris will go into a lot more detail about conservatorship and, most importantly, options to conservatorship. But in general, in California, you can have a conservatorship for someone who's unable to manage their kind of medical and living ability, or a conservator for someone who cannot manage their money, financial decisions, or commonly a conservatorship for both. And the idea of conservatorship, just to mention, is that the court assigns someone to act as a decision maker for that person and accept responsibility. In some ways similar to how a parent is responsible for their children. And in conservatorship, once it's set by the court, it's not forgotten. The court actually monitors this and is auditing every 2 years?
So so that works like this. It's year one, so it's all the odd years. So year one, and then biannually after that, typically it's year one and then 3, 5, 7, and so forth. But initially, they do have a mandate to look at how things are going every single year. And it's only after the judge is satisfied that things are going smoothly and there's no cause for concern that they go to that biannual schedule. Sorry.
Oh, yes?
How does conservatorship differ than the power of attorney?
So the question was, how does conservatorship differ from power of attorney? And I'll hand it to the attorney.
So we will be talking about this later, but let me give you this because it bears hearing, it bears repeating a few times. So let me just say it right now. It is probably one of the most misunderstood areas, and once you explain it, it really helps people see why we go one direction versus another. A power of attorney is a sharing of our decision-making authority. If I give my wife power of attorney, that means that I have shared my ability to go make decisions over things that are just in my name, like my individual retirement account, my IRA, or something like that. That she has now the ability to go call the company and do things. That's a sharing. I don't stop having that ability, all right? A conservatorship is a vesting of my right to call my IRA manager in my conservator instead. It's a civil rights issue, and it's why the courts spend so much time making sure that it's right and necessary, and that there's here's the constitutional term, no less restrictive alternative. That's what they look for. So taking away someone's rights and vesting them in another person, that's under the umbrella of conservatorship. Sharing our rights with somebody for convenience, that's power of attorney. And there's pros and cons to powers of attorney, but we'll talk more about those as we go.
Thank you. Also, just to mention, people may have heard of different types of powers of attorney. Chris will talk about these later, I suspect, but there are different types of power of attorney that do have different roles in estate planning situations, I guess would be the best way to put it. And what you really want to keep in mind here is that when we talk about conservatorship, it's frightening. It's about taking away someone's rights. The court is very, very cautious. This is not something that's rushed into. For example, that's partially why I'm up here. One thing courts require is that they need a doctor to give an opinion saying the person really lacks this ability. You can't just show up and take it away from someone. Also, besides those opinions, people always do have the right to challenge a conservatorship. So even if someone has been conserved, they can always go back to the court and say, I disagree with this, and get it challenged by seeing someone else like myself, another doctor, to kind of challenge that and go forward in court. So it's meant to be a very cautious program. So you want to keep that in mind, because people tend to sometimes assume the worst about it. It's not about taking over, it's about protecting, I would say, is the main thing.
Yeah, and there just can't be a better alternative available. There can't be a better alternative available, or the court won't grant a conservatorship. Yep. So,
What does that mean? There can't be a better alternative?
such as the power of attorney that was mentioned. So if there is a power of attorney and that can get the job done, then the court is going to say, do that.
Stay there. Okay.
Right. We're going to do this only when that doesn't work.
Okay.
And that doesn't always work. And we'll talk a little bit, if we have time, about ways that sometimes doesn't. So it's option 2. It's precipitated. I'm going to skip ahead to the very end of the slides, because there's a slide in there where I talk about how I view conservatorship. And I think Dr. Lande has a similar view. If you think about bankruptcy in the context of financial management, last resort. It's a body of laws that are there to protect us if we have no better alternative. But you're certainly going to do everything you can to avoid it.
Okay.
So we don't pre-bankrupt ourselves, right? It's the same way we don't pre-conserve ourselves. We do everything else. Yep.
And I will say one thing, and Chris can correct me if I'm wrong. Many people in their estate planning have created a trust. Often the trust has some statements in it describing what should happen so you don't end up in a conservatorship. It has those steps already lined out, but Chris will talk about those. So that's kind of how that happens. You don't have a conservatorship set up, but you have the steps set up for what will happen if something goes wrong. So really, going back to conservatorship, the idea is here that the court has determined someone's lost their capacity, their decision-making capacity. And what that really means when we think about capacity is just the ability to do something, the ability to carry out an act. More specifically, especially for legal things, the ability, like it says here, to engage in legal actions or complete documents, the ability to actually pay your taxes or do things of that sort. And really, what I'd like to say is it's this idea of a person's ability to understand their situation, understand what's happening, and what their options are, to be able to consider those options in a reasonable fashion, things about the pros and the cons, and then make a choice in their best interest. I will mention that we don't have to like someone's choice. We can disagree with it. We just need to make sure that they made a choice that they thought about in an effective fashion, because anyone can make whatever choice they prefer. And one thing I will say is that when you see a medical professional, we do have a slightly different perspective on capacity compared to the courts, which is important to keep in mind. We tend to look at capacity as more task specific, meaning you can lose an ability to do one thing, but still do other things. That might be why if you've had an older parent, maybe their doctor told them, you can keep driving, but only to the grocery store, and you shouldn't drive at night. Now, you may disagree with that, but that's the idea, is that really they're saying that you have lost that capacity to do it generally, like you probably shouldn't drive to LAX and pick someone up, but in a limited fashion, you might be okay. And that tends to be how we look at things. We also tend to look at capacity as limited depending on the situation. The most obvious example is if you're in a coma, you lack decision-making capacity and someone else needs to decide things for you until you come out of that coma. So medically, that's how we tend to look at things. That's one challenge sometimes with the court, because the court looks at it a little bit more like an all or nothing factor. We wanted to give you just the information if you're curious about looking these things up. The probate code that describes this for California is code 810 to 812. I will say it's fairly consistent throughout the country, but there are differences.
Oh, I think California's clearer, actually. California's actually got a very good probate code in the sense that it's, and I've practiced in 3 states, I'm still licensed in Oregon. No offense to those other states, California does lay it out very clearly in 810 and 812. I often refer people to those code sections because it really just, especially 810, really just lays out, you know, what it means to have capacity, and as these other points say, it says right in the code, it's not just a diagnosis, it's the actual deficit. And then probate code section 811 talks about what those deficits look like. And 812, so 811 is where Dr. Lande spends a lot of his time. 812 is where I spend a lot of my time because it talks about how a person must present to an attorney or somebody sitting across the table from them in order to sign a legal document. But really interesting thing about 810 is it says we start from a presumption, a rebuttable presumption that everybody has capacity to do the things they want to do. And that's kind of a nice, simple way of thinking about it. And then we look and say, okay, but is there evidence to the contrary? But we start from the assumption that everybody has capacity.
Yes. And one thing also I'll mention, a nice thing about the internet is if you're curious, this is all available freely online. Look it up, it pops up, and it's actually not written in legalese, it's written in a way that makes sense. So I can read it and understand it without being an attorney. You guys can read it and really clearly see what it means if you're curious about those things. The key points of loss of decision-making capacity in California is that you need to have what they call a significant mental deficit. That means that a person has something impacting their ability to think clearly. This could be like dementia. And it's not just enough to have dementia, though. You actually have to show that the dementia is really impacting thinking skills. So, for example, in my field, we do a lot of numbers and statistics. If you ever have a neuropsychological assessment report, it's got too many numbers, honestly. The reason for that is we're comparing people to other people of their age and education. To have someone qualify for dementia, you should be below the 3rd percentile in most areas of a certain skill. So, for example, if you're testing someone's memory, we say that memory is bad enough to qualify as dementia if someone's doing worse than 97 out of 100 people of their age and education. That's the idea of it. So again, we're trying to be cautious, not jump to conclusions about people. So the court says you have to show this significant mental deficit. Oh, one second. And it can be because of a condition affecting thinking abilities. Interestingly, it can also be of conditions affecting emotional functioning, because we know when we're emotional, sometimes we don't think clearly. So that is a component of capacity. And then from that, it's not enough to say that that would make someone lack capacity. We also have to show that it's specifically affecting the abilities that the court is concerned about. So for example, financial mismanagement, being taken advantage of, being unable to think clearly when a challenge arises. Like, I work a lot with adult protective services, for example. We see people sometimes whose houses are literally falling apart. I will give you 2 dramatic examples. In the last 15 years or so, I've been to 2 different houses in the county, because I often go out with adult protective services and see people in their homes, best way to really see how they're doing, where you can see the sky through their ceiling. That's what I mean by falling apart. But these people will tell you they're fine and they're handling everything, and even though the county says you have to get out of your home because it's got to fall on you, they won't. So my job in that case is to go in and determine what's going on. Why are they thinking this way? Why are they not able to accept help? Because the county is trying to help in most of these cases. And that's what we're looking for. That would be that lack of capacity, someone who doesn't recognize the problem or has ability to form a solution to the problem. Those types of things. I would say most of us can use a little bit of help at all ages. It does get a little bit worse as we age, but I'll give you an example. I would actually say being unable to sign your name at 95, barring a physical problem, would actually be a sign of some type of impairment, to be honest. And the reason I would say that is the oldest person I've ever tested, and she might have passed away by now, I don't know, this is about a decade ago. She came into my office, she was 104. Made the appointment herself, not referred by her doctor, came in and she was bent over completely sideways using a walker because she had osteoporosis, but she came in and sat down and I asked her why she was here. And she told me, well, Dr. Lande, I was listening to NPR on the radio and I heard a story about Alzheimer's disease. And I realized that my daughters aren't getting any younger. One of them just turned 80. And she said, one of them just turned 80. And I realized that if something's wrong with me, I want to prepare for the future to make sure they're okay. You can probably guess, we did the testing. She was fine. She looked better than a lot of people much younger than 104. People, I would say, better younger than 80 and 70. So there's a large variety of functioning. There was even a woman, I think her name was Sister Andre in France, who passed away this year. Did people hear about her? Yeah. She passed away in France, 118. Now, I was curious about this because I said, well, she must have had some cognitive impairment. I tried Googling it and looking it up and researching it a little bit just because it kind of got stuck in my head. No signs of cognitive impairment. Now, she was stuck in a wheelchair because of physical decline. She was blind. Until the day she died, she was complaining because she was a nun and she couldn't go back to serving people. No one was concerned about her cognitive function. It was her physical difficulties limiting her. And that's what she was upset about. She just said, I need to get back out here and do my work. So there's a wide variety of functioning in it. As we age, that's really the major point that comes out, is it's very varied from person to person. Some people are doing just fine, even to advanced age. You might have heard that word senility, or going senile. Have you noticed we don't use it much anymore? The reason is we used to think if you lived long enough, you went senile. Now we know that was actually Alzheimer's dementia. And not everyone has it. We just don't notice them because they're not the ones needing help. So we're realizing that people do quite well through age. Oh, but you had a question over here. So obviously on specific cases, I don't know the details and can't give a specific advice. In general though, you would probably have to be able to show that that person's lost their decision-making capacity, and often that was determined by a court, to really be able to override someone. Now in real life, people sometimes take advantage, maybe on purpose, or maybe not on purpose. They're trying to act in the person's best way, or the best interest. And they don't mean to, and they don't realize what they're doing. Like for example, for Parkinson's, I don't know if people have met people with Parkinson's. Because of the movement disorder, people sometimes assume someone is very impaired cognitively when maybe they're not, but maybe they can't speak clearly or they just can't move, and that makes us think that something's wrong. So you want to be cautious about those types of things. Do you want to say a little bit more about that question, about someone selling, or?
We're actually going to get to some discussion of that type of thing.
It gets complex, but again, especially in California, there are steps to try and protect people and make sure that the best decision is made for them. Okay.
All right. Do you want to touch on?
Yeah. So I was just going to quickly mention different types of capacity you might experience. And I bring this up just to show that point of capacity matters depending on what the question is. So for example, the first one up in here is pretty obvious, capacity to sign a will. This is actually one of the simplest capacities you can see out there. To create a will, all you really have to show is that a person knows what they have, who they intend to give it to, and who their potential heirs might be. So for example, if someone really hates that one boy and they don't want to give it to that one son, that's okay, they can make that choice, but if they don't remember they have a son, that's a concern. So it's actually very simple to create a will. You don't have to have a lot of capacity. People with dementia can create wills, as long as we can show they're not impaired or being influenced in an inappropriate fashion. I'll go ahead, sorry. Another type of capacity that comes up a lot in my work is donative capacity. So someone may want to give something away. A little bit different, very similar to a will, but the idea is the person recognizes they're not going to get it back. This comes up, for example, I saw someone in Santa Barbara years ago where he was making some changes to his estate planning, a relatively wealthy person, and he was leaving more to his kids and changing some of his charities, and the bank just wanted to make sure he was okay. He was fine. It was just, this was after one of the real estate busts, so he had lost a lot of money, so he had to reevaluate what he was giving to people. You know, it was fine. They were just concerned because he actually had terminal cancer at the time. So the bank just wanted to make sure nothing weird was going on. Other types of capacity, in general, the ability to engage in any type of contract or to create a trust is a little bit more showing that if someone has the ability to understand that this is a contract. So they need to understand that it's a contract, they're permanently agreeing to something, again, it can't be undone without more complex business maneuverings. And then one last one that people don't tend to consider as much, although the country is getting better about this, is the idea to make medical decisions. Anyone know what you need to be able to do to make a medical decision? Couldn't quite hear you. Have a healthcare directive. So that's one of the things that we now have to help people. But in general, for medical decision making, you need to be able to show that you have an understanding of your condition, that you've been given a possible course of action, including several courses, and that, again, you can realistically consider the different choices and make a choice. So there's three components. You have to understand the condition, understand possible treatments, and then be able to express a choice in a consistent fashion. So that's really kind of what you look for those types of decisions. One thing, again, going back to dementia, we see a lot of people with dementia. One of the first issues in that condition is you start to lose awareness of how it's affecting you or that you even have the problem. So that's going to affect their healthcare decisions because they might be making a decision that just doesn't make sense for them. Now, the questions kind of come up a little bit earlier about what about someone who's just showing normal changes in age? So I wanted to address those because it's easy to assume the worst about someone, especially when they're doing something we don't like. You know, they're making a decision we don't agree with. You want to realize that for most people, normal aging without any illness involves really the major problem being slowed speed of thought. What happens as we age is we start to lose neurons, those are your brain cells. And by the way, before anyone's wondering, it starts in about your 30s. So we're all losing them in here probably. You start to lose neurons, and as time goes on, you lose a little bit more. And just like the freeways out here, when a lane gets blocked for construction or something, things slow down. Same thing happens in your brain. For most people, that's the major aging change. And what that means is, as long as you give the person enough time to make a decision, they can do a fine decision. As long as you give them enough time to learn new information, you don't rush them, they can take things in effectively. That's honestly one of the major reasons you see a lot of people getting involved in scams nowadays. Scams never say, I'll get back to you next week to see if you want to do it. It's always like, I'm at your door right now. Do you want to do this? Or I'm on the phone right now and you got to give me that number right now. It's always about that urgency to it. So normal changes are slowed processing. On a related note, problems of complex concentration. Have you all noticed that maybe you drive a little slower now that you got a little older? As we age, most of us, hopefully I do, tend to drive a little bit slower. And that's because your brain is actually forcing you to drive at the rate you can handle. Because if you were still driving like you did when you were 16, you wouldn't notice everything happening around you and you could be in danger. So as we age, that kind of complex concentration ability, keeping track of everything around us, declines a little bit. And then in general, we know that problem solving for new things gets a little harder. So for those of you who maybe had to teach a parent how to use a VCR or a cell phone or an Apple iWatch, that's what you're looking at. It's not that anyone shouldn't be able to do these things, it just takes a little more time, a little more patience as they're getting older to learn these things, and people need to be able to want to do it. Isn't our brain wired a little bit differently for doing things by hand like handwriting versus digitally? And that is true. Some of it's just when we learned it. So people like my kids now can do things on computers I can't do. I was going to mention one other thing I thought was kind of interesting. There's actually research that shows if you take notes, if you handwrite the notes compared to type them, you remember them better. So there is some difference there that we don't fully understand why, but that comes up. And really the key there is actually taking the notes. Because as we get older, our memory is slowing down. It's harder to learn new things. It doesn't mean we can't do it, just need to take your time and practice it. So if you take notes when you're talking to someone or even repeat things back to them, you're more likely to remember it. And really that's true at any age. I have 3 teenage boys, and that helps a lot when I give them chores, to have them repeat back to me what I expect them to do. But as we get older and our brain is slowing down a little bit, the way to support it is by practicing it, taking our time and focusing, and using the information right away. So if someone tells you something, just summarizing it back to them. Oh, so you said this. Just a quick little thing that really helps it stick in your memory and improve that functioning. One thing the American Medical Association actually looked into a couple years ago was when people do their annual Medicare evaluation, where you go in and they issue that really quick check, they were thinking of doing baseline testing. They actually studied it and found that it didn't seem to help that much because when things go wrong, it's usually pretty evident.
Yeah.
So it's good enough to have to report it when it happens.
Are you talking about those 3 little questions? Yeah, those
Yes.
are worthless.
Yeah, they're not always the best, but it's something. It's more about being aware of things. I will say one way to really know if there's a concern in yourself or a loved one is someone loses their ability to do something they've always been able to do. That's a problem. So I always ask people, are you having any trouble with your cell phone? Now, before anyone panics, if you never like cell phones, that's not a problem. And if you buy a new cell phone, that's not a problem. Those are hard for all of us. But I mean, if you've had a cell phone for a couple years and you've been able to FaceTime your kids or text and things like that, and now you can't text with the same phone, and it's not a physical problem, that could be a sign of something going wrong with thinking abilities. Another common one I ask people is remote controls. Again, if you've had a TV for a while and you've had that remote control for years and you've never had trouble and now you're having trouble figuring out how it works, that can be a concerning sign. And if you only turn on the TV once a month, it's not a concerning sign. I more mean when you're doing something regularly and now starting to struggle is where you start to get more concerned about it. And now that I've scared everyone about aging, I did want to mention there's some good things that come with aging, predominantly that we build wisdom. So like you said, we take all that information and we have all that stuff packed in our head, and as long as we can take our time to use it and go through it, we generally can have a pretty good plan to how to go forward. That's the whole idea of wisdom. We have all these life experiences, we know how things work, we know what this likely means, we know what decision might be the best in this type of situation, compared to a 20-year-old who may have never had to deal with this problem. I'm just going to finish up with a little bit about kind of how to recognize cognitive impairment and just mention a little bit about dementia and then hand things back over to Chris. So as far as signs of cognitive impairment, I just touched on one of them. You do want to look for forgetfulness. Forgetfulness is not a normal part of aging. Slower memory is normal aging, but really not remembering something, especially if you've been given a hint or a cue, that would be surprising. Besides forgetfulness, I just mentioned the inability to remember how to do something or adapt to new situations. That's problematic. So if someone has something new come up, it's going to take a little longer to learn it, but if you really can't do it, that could be a concern. We talked about those kind of functional changes. One thing I will mention, loss of orientation. If someone comes to see me, one of the first questions I ask them is, what's the date? And before all of you say, well, I'm retired, I don't need to know, you still know what month it is and you know what year it is. That's what someone who should be able to tell me even if they don't know the exact day of the month. Usually should know the month, the year, generally maybe about the time of month. Is it the beginning or end? Maybe what are the upcoming holidays? If someone's really off on those things, that can be a sign of cognitive impairment. And then generally, I'm sorry, what was that?
It can be very confusing in the stores these days.
True. And then my last one up here is just that, we're all very intuitive people. You can often tell if something seems to be wrong. Someone just seems off, maybe they're withdrawing, not interacting as much. Something seems questionable. That's when you might wonder what's going on there. May not be something serious like dementia. It could be someone who's become depressed, maybe someone who's misusing medication or being too much. We had a patient recently who was using a lot of Ambien, and really that was the problem. When their doctor took them off it, they improved significantly. Just they've been using Ambien for years and they didn't realize that a lot of medication has a bigger effect on you as you age. I know everyone's here because they know what dementia is and they're kind of aware of the idea, but I wanted to say a few things about that. One major thing is there's actually a newer term out there nowadays that you'll see in the court paperwork that Chris brought, and that's the idea of major neurocognitive disorder. So the medical field is moving away from the term dementia, and they want us to use major neurocognitive disorder. The whole reason is primarily it's a little more clear what it means, and also dementia's been around so long that people have built up this idea in their heads about what it means, and they may or may not be right. So some people think dementia means you're losing it or going crazy, and neither of those are really correct. The way to think about this is that dementia is not actually a disease or a health condition, it's a description of functioning. So someone could be functioning at normal for their age, or they can functioning at a dementia level of functioning. For dementia, that just means you're showing significant impairment in at least one thinking skill. For many dementias, that's memory. And it's impacting daily life. So impacting daily life might be something simple, like you're starting to have trouble with bills, or it could be something more significant, like I had an individual whose family came and saw her every morning. They fed her breakfast, they made lunch and dinner for her and put them in the fridge, and she still kept losing weight because she never thought to open the fridge to find the food. So that was kind of something you might see. So dementia, again, clinical syndrome, but not a disease itself. Now, Alzheimer's disease is the condition that's the most common cause of dementia. So Alzheimer's is one type of dementia, but there are many different types. Parkinson's came up earlier. One big difference between Parkinson's and Alzheimer's is that if someone has Alzheimer's, they will eventually develop dementia, and it will be progressive. In Parkinson's, that may or may not be the case. Some people with Parkinson's develop dementia, some do not. Other conditions also can cause dementia. If something is bad enough, people can sometimes have vascular problems in their brain, problems with their blood vessels. That can eventually cause what's called a vascular dementia. That's why your doctors want you to exercise, stop smoking, get adequate sleep. Anything that damages blood vessels in the brain, eventually over time can cause a substantial decline in functioning, especially if you have underlying medical problems like diabetes and you're not controlling that well. So there's lots of different conditions that can cause dementia. Alzheimer's is the one we hear about because it's the most common. It's anywhere, estimates say between 40 to like 80% of types of dementia. And Alzheimer's is kind of the one on the screen back here. Very clear, it's the type that involves kind of a loss of neurons, specifically in this part of your brain, right here behind your ear. Why that matters is, one of the first things you see of Alzheimer's is people have word finding problems. And then eventually over time, they start to have more and more trouble speaking clearly. Because it's by your ear, that's the part of your brain that's responsible for producing and understanding speech. In addition, there's a part in your brain that's, is there a pointer on this one?
The green.
Okay, thank you. There's a part in your brain right here called the hippocampus. This little thing tucked inside there. And if you look here, whoops, I'm sorry, wrong button. If you look here, it's not there in this picture. Do you see that? Your hippocampus is gone. Your hippocampus is the part of the brain that's actually responsible for memory formation. So what's happened there is that that's one of the first things to deteriorate in Alzheimer's, which is why you see that dramatic loss of memory. One reason you care about the type of dementia someone has is different types of dementia show different types of problems. That's really one take home you want from this. And depending on the types of problems is what really determines if someone lacks capacity. Because people can have Alzheimer's dementia and still have capacity. Just depends how severe it is and how it's impacting them. So, as I was just saying, just having those conditions is not enough to show someone lacks capacity. They need to have lost a specific ability that's of concern to the court and, of course, to us as family members. And then for my last part, I just want to mention how do we help people? Besides talking to attorneys like Chris, in general, the idea is always try to start with the least restrictive approach. So initially maybe meeting with someone and helping them pay their bills, maybe eventually setting up automatic bill pay, that's easy nowadays. Maybe eventually hiring them an accountant or someone who can just take over that for them. Or even there's what's called private fiduciaries who will do these things for people. So generally trying to do that. Always being collaborative and empathic, and realize even though someone has dementia, we shouldn't just take over. We should work with them and try to figure out how to help them based on their terms. What are they concerned about? What can we do to help their concerns? And we should tell them what our concerns are. You know, a lot of times people bring clients to my office and they say, don't tell mom that I'm worried that she might have dementia. I can't do that. But I will tell them, I said, why do you think you're here? And they may or may not know. That helps me understand their understanding. And then I'll tell them, I said, you know, people are a little worried that you're having some trouble taking care of yourself. What do you think of that? Because I want to get their perspective on it and see if their understanding of it. And maybe they'll say, well, my kids have always been annoying. That can be a fair answer. My kids expect too much. But I want to see also, can they say, well, you know, I have such trouble paying bills. I've just been too busy to go to the bank. Or maybe they can say, I had no idea I wasn't paying bills. We want to know what's happening there. And working collaborative is going to be the best way to figure that out. Collaboratively also means working with other professionals. So I want to talk to other doctors, the attorney if someone's involved, family, to really kind of have it be a team approach for the person. And realize helping anyone with dementia, and especially with estate planning, it's not a one-time thing. It's going to take time and patience. It's a process. Even with that conservatorship process, that's not something decided right away. It takes, what, a good 6 months at least?
Yeah, depending on the type. Yeah.
Mm-hmm. And there are things the court can do to act more quickly if someone's in danger. But in general, they want to take their time to make sure they're doing it appropriately. And the key point is this: we always want to respect our loved ones' autonomy. We want to keep their ability to contribute to decisions and make decisions that are in their interest and what they want, not just taking over for them. And in general, I'll be handing things to Chris in just a second, but I will mention often when you do need a capacity assessment, because say you do feel that there might be a concern about conservatorship, you can ask someone's personal doctor, but many doctors don't feel comfortable doing this with a client they've known for years. They may also feel that they don't really understand the issues the court cares about. In general, I would say better to have a neutral expert, be it a psychiatrist, a neuropsychologist, someone like that, who can come in who understands how to do these things and will take time and speak to people. In general, for my capacity assessments, they might take anywhere between 2 to 4 hours of a client, maybe over multiple visits, so I can be careful. So a little different than the 3 questions the doctor asks. So you always want to be taking time. The professionals you'd look at would be, again, psychiatrists, geropsychologists, neuropsychologists, and neurologists. Those are the ones who generally do these and who are supported by the court doing them. And the major thing is, tell them what you're concerned about. Tell them the questions you have, because if you don't tell us, we can't answer those questions. But with that said, I wanted to hand things over to Chris.
As you can see, Dr. Lande has a huge repository of knowledge when it comes to this, and that is, as an attorney, an incredibly valuable resource for me. Not only when it comes to conservatorships, but when it comes to any kind of assessment of capacity in my practice. And I bring that up because how many of you have estate plans? I'm seeing a lot of hands go up. Any kind of estate plan. Do you have a trust, a power of attorney, a will, anything? Okay. Most likely, in your documents, it has language about what the trigger is to change capacity from, or change control from you to somebody else, whether it's a trustee or an agent under power of attorney. And I would say that it's getting better, but 85 to 90% of the time, I see that trigger is 2 physicians, that's where I'm going. 2 physicians who must sign. They can't be related by blood or marriage. They have to sign in blood under oath, etc. Look at your documents, because here's the problem. If you, like me, consider Dr. Lande a very valuable expert and somebody that could weigh in on this, your documents cannot say physician. Dr. Lande is not a physician under California law. He is a doctor, and a well-qualified doctor, and the court would agree, but he is not a physician. This becomes a real issue in trying to help get that transfer done. So just the word, right? Because just like I can't say I'm a specialist unless I have designation, Dr. Lande doesn't come under the quote-unquote definition of a physician, a medical doctor in California, right?
Because I'm a psychologist.
Right, but he's eminently qualified to give that assessment. So look at your documents. If you do nothing more today than look at your documents and see if you're using the word physician, as most attorneys have been doing up until recently, when I keep talking about it, I see some change, but and getting that addressed, going back to your attorney to fix it, coming to me if your attorney's retired and fixing it, whatever needs to be done, to make it, don't make it too difficult for the people you're asking to help you when that time comes. You know, remove barriers. The comment was about communication with your family and making sure that they know what it is you want. But I would say that the paperwork matters, because oftentimes your trustee or your agent under your power of attorney is trying to establish themselves with some third party, a bank, a title company, somebody like that. So they need to say, look, I have authority. And if they look at the document and it says physician, and we don't have 2 physicians, that becomes a very practical issue in that moment. The question has to do with, or the comment has to do with using the 5 wishes document, which I share your like for it. It's very helpful and very helps spell out what wishes are. It is not a replacement, though, for an advance directive. I sometimes, if my client has one, I attach it to the advance directive for further context. But so anyway, we'll come back to that, though. So regarding conservatorship, just because we want to talk a little bit about the types that are out there. The general conservatorship on the slide there is often called a probate conservatorship. That's the most common kind of conservatorship. It has to do with people dealing with dementia most commonly, and mostly elderly folks. There are 2 types, person and estate, and they are as you would imagine. Person is going to be focused on the physical, medical well-being, where they live, what their education opportunities are, those types of things. And estate is going to be about protecting their finances and making sure finances are there for them when needed. There are standards that the court looks at in these cases. There is a temporary option which will allow you to receive, to be appointed relatively quickly, sometimes in a matter of weeks if there's some urgency, but there has to be some exigency. The court is going to look for exigent circumstances, like it's a life or death situation, or somebody's about to sell the house out from under someone and they need to get in there and very quickly in court. Most often the court wants to have the time to do their investigations, and so they want to have, it take the ordinary course, which is usually a couple of months in Ventura County, perhaps longer in other counties. There is a limited conservatorship, just so you know. That is for developmentally disabled adults, usually young people who are developmentally disabled, and now they are 18, and their parents want to continue helping them. It's a different type of conservatorship, but some in this room may be familiar with that, and I help with that as well. And then there's what we call LPS conservatorship. That is based on the Lanterman-Petrus Short Act. This was the act that closed the state hospitals and had community-based psychiatric care and whatnot. And the solution for grave cases was that there would be this LPS conservatorship for people that needed that level of care. Dr. Lande, I think, more involved in those. It has to be initiated by the county. I only advise parents sometimes of LPS conservatees, but it's much more done at the county level and initiated at the county level. Absolutely.
Yeah, and actually, primarily this would be someone who's actually in a mental health hospital. It's going to be where this would be occurring. So in this county, the Hillmont Psychiatric Facility. And the major thing to keep in mind about those is they're meant to be temporary, meaning they have to be reassessed annually. Because the concern is someone may have gotten control of their condition, maybe through appropriate medical care or appropriate medication. Their condition is approved now and they no longer need it.
Thank you. And that brings up a point actually regarding these types. The general probate conservatorship is intended to continue on. The limited and the LPS there's a hope that they are no longer needed at some point. And so the court is always looking for opportunities to terminate those more often than with the probate conservatorship. So probate conservatorship of the person is when a court-appointed fiduciary, usually a family member or a professional who does this as their work, is appointed to oversee the personal care of someone. So we've touched on that. And this list here is the types of things that a conservator of the person would be focused on. A conservatorship of the estate looks to whether the conservatee is substantially unable, this is the court standard, this is what's in the law, to manage his own financial resources or to resist fraud or undue influence. So if you think about those scams that Dr. Lande talked about, that's a big indicator that a conservatorship of the estate may be necessary. They are not always done together, but very often person and estate are done at the same time, because the need transcends finance or personal matters. So are there alternatives? Remember we talked at the beginning how this is a constitutional issue. So the court is always going to look to whether there's alternatives available. And the list here, I'm just going to list so we can kind of quickly look. The court is going to ask about, and in fact one of the forms I have today is a confidential supplement. This is on the back table if you want to take a copy. This is a supplement that gets filed with the court confidentially to let them know, and it asks very specifically on the third page about different options that might be available. Is there a power of attorney? Is there a trust? Is informal voluntary acceptance of assistance an option? The court wants to know because, again, a conservatorship will only be granted when it's the least restrictive alternative. There is no alternative other than conservatorship. And other options that are available for alternatives are interdisciplinary team review. So this is something where, and we're moving more toward this, the idea of the assisted decision-making kind of authority, and trying to look at that and seeing if there's a way that we can get by without having conservatorship fully implemented. Community property is another interesting option, or interesting concept, because we in California have this idea: if property is earned or received during marriage, other than by gift or inheritance, it is community property. That means one spouse technically should have the ability to control it. But look there, what about retirement accounts? Remember I mentioned IRAs earlier? Try saying that to a financial firm. Say, well, that's my wife's IRA. I should be able to manage it. They'll say, no, go bring me documents. So the idea of community property is lost on many people. So it unfortunately is not always the option. So then we look at other options. Advanced planning for incapacity. These are legal documents. Advanced healthcare directives. Durable powers of attorney. And notice that the word durable is bold. Durable means that power of attorney is going to continue to work even after we have lost capacity. Okay, so look at your own powers of attorney and see if it contains the word durable. If it does not, that may be an issue, and you can bring it in and we can take a look at it. And then living trusts. Living trusts are a way to manage our property and make sure we receive the financial assistance we need during a period of incapacity. But keep in mind, trusts only manage what's in them. So we have to make sure that our property actually moves into the trust in order to be able to be used to assist us. When, and this gets to a question from the very beginning, when might a durable power of attorney not do the work to avoid conservatorship? And that gets to that crux, that issue that I talked about at the very beginning. A power of attorney is about sharing our authority, but a conservatorship is about removing that authority and investing in another person. So if somebody has dementia, if they're being forgetful, if they are doing things and then forgetting that they did them, or, and we didn't talk about, you didn't bring this word up, but paranoia, I believe, is a symptom of dementia. I see it all the time. I think a lot of us do in our families. A suspicion, a fear that the person that's actually trying to help you is harming you. If those things manifest themselves, then a power of attorney is not going to do the trick, because the principal, the person that is trying to be helped, is not going to act in their own best interests. And I, like Dr. Lande, I have many, many cases where I've seen this actually play out. I think of one right now where a gentleman had a great estate plan, and his daughter was trying to help him, but he kept moving money and forgetting where he put it. And he was fearful that she was trying to take his money when all she was trying to do was make sure it didn't get lost or given to a scammer. So in that case, we had to go to court to get a conservatorship, even though there was a power of attorney, even though the power of attorney should have worked, because there was self-defeating behavior on the part of the gentleman, and that made the conservatorship necessary, and so the court granted that. With regard to advanced directives, I think we're just talking about all of these things in general. Again, if somebody is not making decisions, not able to make decisions on their own, in an advanced directive situation, perhaps the agent that they've named is not available. So in that situation, even though they've given the name of somebody to give informed medical consent on their behalf, that person's not there to help. Alternatively, they may be acting as though they have capacity and saying, no, I don't want this, or yes, I do want this. And their agent, who truly is there to try to help, is saying a different thing. The medical provider is going to say, I'm sorry, you need to get clarity from the court here. We need a conservatorship in that case. All right? And then a trust, again, the biggest issue with trusts, they can be very helpful if funded properly, but they only help as to the property that's in them. They will not help you on the personal side, but a trustee who has assets in the trust can make sure that there's income being paid to you. They can get the financial side taken care of. But on the personal side, you have to have an advance directive. You have to have clarity there. And advance directives are very interesting because they don't just handle the end-of-life decision making. We used to have two documents. We had a power of attorney for healthcare, and we had a living will. Those two documents used to be separate, and if your estate plan goes back far enough, you may have those two as separate documents. But both of those caused confusion, and so they were combined into a single document called an advance directive. And so it handles not only the living will, the instructions as far as what I want at my end of my life, but also decision-making as far as all of those conservatorship of the person authorities, like where someone will live and what care, short of end-of-life care they receive. All of that can be contained within an advance directive. So it's vital that, frankly, I think every adult, everybody once they turn 18, you send that kid off to college, they should have this basic document. They're free versions available, very easy to do. But the most important thing you can do with these is name people that you trust to make those decisions when we're not able to. The question has to do with whether we should name different people or the same people for these roles. And that's a great question. Ultimately, it's going to come down to the specific people involved, okay? But here's how I look at it generally. I look at the financial fiduciary roles, which are executor, trustee, and agent under a financial power of attorney. I see those as one. And I see medical decision-making as another. There's no harm in making the financial and the medical the same person, but if you think that there's benefit to checks and balances, for instance, if you have 2 children and you want to give each of them some authority and you trust both of them and you want there to be checks and balances, go ahead and name one the medical and one the financial, and then make sure you name the other one as backup in each of those situations. The most important thing, second most important thing you can do with these documents is name backups. Because if there's anything the last few years have taught us is life comes at us hard and fast, and we don't know if those people are going to be there when we need them. So it's a great question, but the reality is it's going to be very specific to your family situation. But some people, they like the idea of checks and balances, and some want to have that same person because of simplicity and fluidity. And I will say there are areas where they can conflict. The advance directive, that person gets to decide where mom convalesces, right? The person with the purse strings gets to decide who pays for it and how much gets paid. And those can come into conflict. So you need to make sure these people can work together if you do choose separate people. This brings us to our last official slide this morning, which is on the court's documentation regarding capacity. The court will want to see, and this is another form that was in the back you may have picked up. It's called a GC, which stands for Guardian and Conservatorship, 335. It's a 3-page form, and on the last page is an additional form that's used in cases of dementia, 335A. This is another confidential form that doctors such as Dr. Lande will fill out, and it tells the court how is this person doing, and it's giving medical and psychological input about that person in a way that the attorney is not able to do. So it's a very important document. Here's the other benefit of using somebody like Dr. Lande. He doesn't just hand me back a 4-page report. He gives me that 4-page report and it says at the end, see attached. And then there's another 15 to 20 pages attached of test results and just detailed analysis of what he said in this report. The courts love Dr. Lande and people like him for that because it gives such valuable information about the person. So, but keep in mind if you are looking at conservatorship, these are 2 confidential forms that must be filed, and those 2 are often the most important forms to the court. They look at them and they take a lot of guidance from what is in those documents. So what I would say is if there's no alternative conservatorship, make sure you work with an experienced attorney, okay? Especially if the estate is needed, conservatorship of the estate. The court is going to want to see a conservator of the estate represented by an attorney because they know that an attorney is going to give the proper guidance on making sure accountings are done and proper forms are filed and basically just general management is done correctly. Review those forms that we've just discussed and make sure that they're filled out completely. And don't just rely on the general practitioner. As Dr. Lande said, they're often in a tough position of knowing this person for many years and not wanting to be the one to say these things about that person. Get an independent analysis done if you possibly can. All right, and this bringing it full circle. This is what I was saying at the beginning. Think of this as the bankruptcy of elder law. It's there, it's very important, but it's only there if we absolutely need it, and we do everything we can to avoid it. So first of all, I just want to say thank you for being here today, and we can take some additional questions, and then if we run out of time completely, we can take more offline, because I know we do need to bring it to a close. We're over the 1 hour allotment. So, but let me just say that with the cost of conservatorship, It's substantial to get a conservatorship established, and then the ongoing costs that those reports and accountings that are required. That's why we do everything we can to avoid them. But I couldn't give you an exact dollar amount because each case is so unique, okay? But just know that that's why it's a last resort. There are freely available forms. They are not perfect, but they are there for free, and it's better than nothing. And you should look or write down and Google a statutory power of attorney. That's the term to use, statutory form power of attorney in California. It will bring up a form. You'll know you have the right one if you see a bunch of things listed, A through M, and then there's N that says all the above, and you can initial next to it. That's the form I'm talking about. It's better than nothing, and but if you want something more robust or you have any questions, then you should see an attorney about it. All right, well, thank you very much, and any further questions we can take offline, right? All right, thank you.
Thank you.